In today's India, law of sedition is a very big legal controversy. We will be discussing that in this video. But before we move any further, let's have a quick meaning of the term sedition. The term sedition, according to Oxford Learner's Dictionary, is the use of words or actions that are intended to encourage people to oppose a government. Legally, under section 124A, this section has been stated. The section is on the screen. Let us have a small overview of how this law came into existence in colonial India. It has an interesting past. In pre-independence era, the Indian Penal Code came into existence in 1860. Surprisingly, there was no law of sedition at that time. It was drafted by Lord Thomas Babington Macaulay and was enacted in the year 1870. According to a study, the Britishers became aware of the necessity of such a law after the revolt of 1857 in the light of increased Wahhabi activities. It was only then the law was enacted into the IPC as Section 124A. Throughout the British Raj, many Indian freedom fighters, including mentionable persons like Bal Gangadhar Tilak, Mahatma Gandhi, Bhagat Singh, and many more, were accused and imprisoned under the case of sedition. After we got independence in 1947, this law has been used in different times and ways. But the mentionable point is that the term sedition was dropped from the Constitution of India by K.A. Munshi. Although this word was present in the draft constitution primarily, but it was removed when the constitution was adopted finally on 26 November 1949. The validity of sedition law was tested for the first time in independent India by the then Punjab High Court in Tara Singh Gopi Chand versus the state. The High Court held that Section 124A was indisputably a restriction on freedom of speech and expression and stated that it was in contravention of the fundamental right under Article 19 of the Constitution. It was this judgment that prompted the Jawaharlal Nehru government to introduce new grounds on which the right could be reasonably restricted. Later, in the time of Indira Gandhi, this offense was made a cognizable offense. Now, according to the Code of Criminal Procedure, the term cognizable offense means that the police authority has the right to arrest any person without any warrant under this charge. Now, let us come to the point of today where the law of sedition is being used enormously. This chart alone shows us the number of cases are increasing day by day, from 35 in 2016 to a whopping 93 in 2019, an almost 160% increment. But the surprising fact is that the rate of conviction has dropped massively to 3.3% in 2019 from 33.3% in 2016. That means only one thing, that this charge is being misused to some extent. The issue of poor definition of law of sedition was raised by Justice D.Y. Chandrachud. In an important PIL, he stated, expression of views which is dissent and different from the opinion of the government cannot be termed seditious. Present Chief Justice of India, Justice N.V. Ramana, raised a question on this law in an open court to the government as to why a democratic country like India still needs a law of sedition which was used to curb the voices of Indian freedom fighters. In a hearing on July 15, the Chief Justice compared the use of sedition law to a tool given to a carpenter to cut a piece of wood, and he uses it to cut the entire forest itself. Law of sedition is like a coin, having both positive and negative sides. It can be harmful as well as can be a reasonable restriction if it is used properly. Thus, this law in itself is a big controversy. Thank you.